Hi, my name is Duncan Byrne, and this is my 1931 case on Near versus Minnesota. So, to begin, some of the circumstances that caused this dispute began to rise, as a Minnesota newspaper titled the Saturday Press accused local officials of dealing with gangsters, as well as many other insulting messages towards the state. This newspaper was published under a Minnesota state law that restricted the press for publishing media that it saw was unfit for publication or defamatory of the state or national government. This was known as the Public Nuisance Law and prompted Minnesota state legislators and targeted police officer Floyd B. Olson to sue its authors, Jay Neer and Howard Goldford, and request the permanent injunction of the Saturday Press. So initially, the state court of Minnesota ruled in favor of the state of Minnesota and was backed up by its state Supreme Court. Their decision was to further restrict and prevent the publication of the Saturday Press over charges relating to that previous Minnesota law. This law covered topics, of course, relating to preventing public nuisance and defamatory insults against individuals or the state government, in which the Saturday Press violated this against Olson in the state of Minnesota. This prompted Neer and Goldford, as representatives of the Saturday Press, to appeal to the federal Supreme Court over the state of Minnesota's ruling. So, before resolution was met and passed the Supreme Court, the justices on the Supreme Court were actually very divided on which side to support. So, on the dissenting side, four justices agree with the state of Minnesota's case, as Justice Pierce Butler, one of the four justices, argued that by limiting the state's role in regulating media and the freedom of press, it gives the freedom of press a meaning that was not previously recognized in the 14th Amendment and the Declaration of Independence, and would weaken the state's power over the population. However, for the majority, contradictory to Justice Butler, Chief Justice Charles Evan Hughes writes for the majority that of the other five justices, and states that the liberty of press and freedom of speech is protected by the Due Process Clause in the 14th Amendment, as well as mentioning famous ideas from William Blackstone that provided that the injunction of the Saturday Press would contradict the essence of liberty in English society. So there was two parts of the Constitution that were involved in this case. The main one being the First Amendment, as the amendment defines the freedom of speech and press protected by the government against federal censorship. However, it never specified the restrictions against states to restrain the press, leading towards states to crack down on newspapers that spoke out against the state government and their actions. The 14th Amendment is also referenced to in this case, as the amendment references that the state cannot infringe on their citizens' rights. It protects citizens from abuse or unfair treatment by the state or federal government. The 14th Amendment also references to the process of voting for representatives and the roles in the executive branch. So one of the most important precedents related to Near versus Minnesota, as I previously mentioned, was Minnesota's law of public nuisance, which was defined as in the business of regularly and customarily producing, publishing, etc., a malicious, scandalous, and defamatory newspaper, magazine, or other periodical, is guilty of a nuisance and authorized suits, as in the name of the state in which such periodicals may be abated and their publishers enjoined from future violations. In summary, the Minnesota state law prior to Near versus Minnesota gave the state the ability to restrict or restrain any media it saw as defamatory or as a public nuisance. So, in the end, the court's decision ruled in favor of Near's party by a 5-4, as it was argued that Minnesota, other states, and the federal government do not have the ability to restrain and restrict media that is seen as malicious, scandalous, and defamatory as an act of public nuisance. So some of the results and implications were that by restricting the states on their ability to act upon censored publications, the resolution helped provide a clearer meaning for the freedom of press and speech mentioned in the Constitution and Declaration of Independence. Near versus Minnesota also helped define that the government nor any state can censor the press or speech in advance that it may be seen as defamatory or a public nuisance. However, this still left the exception that defamatory insults made in newspapers after its publications may be violated in a criminal or other fashion violating a state or federal law. So there's two main sides about the discussion of surrounding this case. So the obviously more positive side is that it benefited authors and publishers of newspapers, as well as the safety of the newspaper definitely increased with the Supreme Court ruling. Although it did stop newspapers from being published, be like restricted, uh, being published in advance, it did discourage defamatory statements, as a newspaper can still be charged after its publication. And for the more negative side, in conjunction with the resolution of Neer versus Minnesota, the Minnesotan law of public nuisance, as of course, was abolished, with a new federal law giving the federal government the power to define the freedom of press and free speech. This most likely did not please some states, as prior to Neer versus Minnesota, states regularly restricted newspapers and media it saw as defamatory or as an act of public nuisance. So, of course, there's the question: what could have America been? Could have America been like if Neer versus Minnesota was not decided the way it was? So, in my opinion, if Neer versus Minnesota was decided against the party of Neer and favored Minnesota, it would have had very drastic consequences on the way modern day media, newspapers, and most likely society would have to operate. Firstly, it would have solidified the government's right to restrict the press and give the states the ability to shut down any newspaper or article that insulted or defamed the government or any state government. This will leave our press and media today to likely have less freedom to speak publicly, which most likely probably cause some revolts against the federal government. Eventually, it may even erode the freedom of the press and speech to an extent that those rights will be nearly stripped away from the people. The government would be more centralized than it is today, and there could have been more restrictions following Neer versus Minnesota on other freedoms and rights. So, thank you for reading, and I guess in this case, watching. And here's my bibliography.